then please do send them in to us. I'll be very happy to look at them. Okay, so that means that first up is Emma Doble. So I'll hand things over to Emma Doble for her presentation.
Thanks, Steve. Hello, everyone. Right, I thought I'd start off with a few statistics. These are the most up-to-date statistics that I could find. They're published by Mental Health First Aid England just over a month ago in May 2020. So stress and depression are now the second most common cause of sickness absence after musculoskeletal conditions. So I don't think it's going to be long until stress and depression get into first place. But at the moment, 1 in 6 workers will experience depression, anxiety or stress at any one time. The cost to employers is about £35 billion a year. Work-related stress, anxiety and depression accounted for 54% of working days lost in 2018 to 19. 72 million working days are lost annually, and 1 in 5 people take a day off due to stress, but 90% of them give a different reason for their absence, which is pretty surprising. And I'm going to come back to that last point in relation to a case called A against Z a bit later on. So moving on to the next slide then, most of the cases that I tend to see as an employment lawyer are disability discrimination claims. They rose by 26% between 2017 to 18 and 2018 to 19. So the volume of disability discrimination claims has risen 8 times faster than the growth in all claims. And it's thought that this is largely down to stress-induced mental health issues, together with a growing readiness amongst employees to bring claims relating to their mental health. And we've certainly noticed an increase in the work that we do. Most of the cases have a mental health related discrimination claim included with them. So the highest award in a disability discrimination claim in the 2018 to 19 year was 416,000, or just over, which is a shockingly high figure, and I'm pleased to say wasn't one of mine. The average award was 28,000, but to make you feel a little bit better still, with the average award obviously being the mean award, the median award, so if you line up all the awards that have been made, the one that sits right in the middle is around £12,000, so that's slightly better. Now, of course, we still also see unfair dismissal, capability dismissal cases, and I wanted to just give you a quick example of a case that I had recently that was a capability dismissal case. Now, it was a sort of dream case for me as an employment lawyer, because we had plenty of notes where the employee had been off sick for a long period of time, and in those notes of meetings he said every time, I just don't see that I can come back, I don't see that I'm ever going to be well enough to be able to come back. He had various physical disabilities, but he also had anxiety, and following his mother's death he said that he couldn't drive to work anymore because he'd have to go past his mother's house and there was no other way that he could get to work. Now, they sought occupational health advice throughout, and again, very helpfully, each of the, I think it was 3 or 4 occupational health reports said, we just can't tell you when he's going to be able to come back, and in our view, we can't see him ever returning. So they're the sort of perfect documents that you want when you're dealing with a capability dismissal case. Now, ultimately, we managed to get the claim withdrawn, because they had a capability dismissal hearing, and as part of that capability dismissal hearing he was accompanied by his union representative, and the manager who conducted that hearing said that the employee and his union rep went in and out of the meetings talking about the various options. Now, he'd actually brought his disability discrimination claim and his unfair dismissal claim based on him not being offered ill health retirement. And one of the slight risks with the case was that the person who dealt with that capability hearing couldn't remember whether they'd ever discussed ill health retirement, and it wasn't in any of the minutes. It was mentioned in the dismissal letter, but I was slightly concerned about that letter because it seemed as though it was a bit of a cut and paste job from a previous capability dismissal and didn't even have the claimant's correct job title in it. So it wasn't clear whether they'd ever actually discussed ill health retirement at all. And of course, a failure to offer it can potentially render a dismissal unfair. So there was a bit of a risk with that element of it. But helpfully, as part of taking the witness evidence from the manager, he told me that the union rep had agreed to the employee having a medical compensation payment as part, sort of through his pension, and therefore ill health retirement was never taken up as an option by the employee. And when we pointed this out to the solicitor on the other side, union solicitors, they accepted it and withdrew his claim. But it's really just a flag that capability dismissals are very much alive and well and are often brought where an employee is dismissed as well as a discrimination claim. So the Acas guidance around mental ill health, well, it ranges from feeling a bit down, low mood, to common disorders such as anxiety and depression, and more severe and far less common conditions such as bipolar and schizophrenia. And I have had a couple of disability discrimination cases which relate to bipolar. Just moving on to the next slide. So signs to look out for, signs of employees' mental health. Now, of course, this is not an exhaustive list. These are really just examples, things that we've noticed. One of those can be changes in usual behaviour, the employee's mood and how they interact with colleagues. And only this week I had a client inquire about a situation where an employee who was a very good performer and everything was always fine, but suddenly he'd taken to communicating with his managers in capital letters and effing and blinding throughout these texts and emails, and their immediate reaction was to have a meeting with the employee and really try and understand if there was anything behind this that was potentially a stress or anxiety related issue. Changes in the standard of work or their focus is sometimes a sign that can be noticed. They may appear tired, anxious, or withdrawn. They may have a reduced interest in tasks they previously enjoyed. There could be changes in appetite or perhaps an increase in smoking and drinking. And again, I've seen cases where employees are turning up to work in the morning smelling of alcohol, which is a new thing. And when they've had the chat with the employee, is there anything we need to know about, then often it turns out that there is some kind of stress-related issue going on in their lives, which has led to the increased intake of alcohol. And also, obviously, increase in sickness absence is going to be a flag, but turning up late to work is also quite a common example, particularly relating to anxiety disorders, anxiety conditions. Perhaps people take medication, which means it hasn't taken effect until sort of later in the morning, and often they are turning up late to work. Just moving on to the next slide. Causes of workplace stress. Well, again, this is not an exhaustive list. These are just really examples that we've included here. So, of course, excessive working hours or a pressured high level of work is a common cause of workplace stress. Relationships with colleagues at work, perhaps there's personality clashes there. A lack of support at work, or the other end of the spectrum, being micromanaged by their manager can cause stress. And if they're suffering any bullying, harassment at work. Now, in terms of the excessive working hours and workload, we all live in an instantaneous world of emails where people can't escape their emails. Often they're on their phones. Everyone wants answers immediately to emails. It's not like the old days of letters and memos where you could take the time to reply to things. And I think there is an increased expectation, demand. Many people work in high performance working cultures and strive for a work-life balance. And all of these elements really contribute to an increased stressful environment. And I'm sure that after the last few months with people working from home, juggling homeschooling, managing personal issues at home, that these are all factors which are going to potentially increase stress claims in the future. The next slide deals with personal stress, may be caused by a range of issues, for example, breakdowns in relationships, bereavements, financial problems, family or health concerns. And I wanted to just pick up on the bereavement one, because I had a case recently where an employee didn't receive his end of year bonus. He worked as a telephony assistant in a call centre, and the quality of his calls meant that he didn't get a performance bonus at the end of the year. And he brought a disability discrimination claim, saying that he'd suffered a bereavement earlier in the year when his father died in the June, and that as a result of that, he'd suffered depression, and he claimed that this was disability discrimination. Now, we argued that he wasn't disabled, and we asked for a preliminary hearing to determine this. And as part of the preliminary hearing, we said that he'd taken time off for his father's, we knew his father had died, he'd taken 2 weeks annual leave to go abroad to arrange the funeral where it was taking place. But he then returned from annual leave. There was no sign of any emotional issues or that he was struggling emotionally. He never mentioned it to anyone. He carried on working in his evening job in addition to his day job. And so we took the view that he hadn't or wasn't suffering from a disability in any way. This went to tribunal. Tribunal agreed that it was a life event and that it wasn't a disability. The case wasn't without risk because the employee had taken himself off to his GP and been prescribed antidepressants at some point after he put his claim in. But in any event, the tribunal said it wasn't a disability. He took it to the Employment Appeal Tribunal, who agreed with us and the Employment Tribunal, saying that they thought it wasn't a disability. And he even took it to the Court of Appeal, and we had to set out our reasons why he shouldn't have leave to appeal. And fortunately, he wasn't allowed to take it any further. But that case could have been very different if the employee had gone to his doctor and been prescribed any form of medication, or said that he was suffering from depression shortly after that bereavement. Then it may have changed the case completely. So it did turn on its facts, but it can show how a bereavement may cause a disability, but not in every case. So moving on to the next slide then. So disability discrimination, the duty to make reasonable adjustments. There's many forms of disability discrimination, as I'm sure you know. One form of it is the duty to make reasonable adjustments, and we're not going to go through all of the different types today, but it's just a reminder really that disability includes mental impairments. It's not just physical impairments, and I know that whilst HR are very well aware of that, sometimes managers do forget that, those who are sort of managing the employees, line managers, and it's something we'll come back to later on. But it has to be a long-term and substantial adverse effect on the employee's ability to carry out normal day-to-day activities. It's not a huge hurdle for employees to overcome, and in the disability discrimination claims that we deal with, where an employee can produce an impact statement setting out why they can't function without their medication, and if that's supported by medical records that show that medication has been prescribed, then more often than not that a tribunal is likely to find that's a disability if they've been taking that medication for a year or they're likely to take it for more than a year. Not all mental health conditions are disabilities. We've had cases where the employee suffers from low mood. Perhaps the occupational health report says that they've been prescribed medication but have chosen not to take it, or took it for a month and stopped taking it. There are often ways around showing that these conditions are disabilities, but much will depend on how long they've taken medication for and how it affects their day-to-day activities. And remember that the discrimination and failure to make reasonable adjustments claims can be brought by not just employees, but also those applying for jobs and those who perhaps have left and are seeking a reference. Now, just to mention here that whilst there may be a disability, the employer must also have knowledge, or ought reasonably to know about the disability. And I mentioned earlier the case of A against Z, and I wanted to just tell you a little bit about that case. It's a fairly recent case. It's anonymised, which is why it's A is A Limited, it's the company, and Z was the employee. And in that case, Z was dismissed for poor attendance and timekeeping issues, and she brought a claim for disability discrimination. Now, she produced her medical documents as part of the proceedings, which she had to do, and the company looked at those and said, yes, we agree that she's disabled. She suffers from stress, depression, low mood, and schizophrenia. However, she'd never told the company about them. So they pleaded that they didn't have knowledge or constructive knowledge of her disability. So she'd had numerous sickness absences, including a 2-week stay in a psychiatric unit, which she'd attributed to physical ailments, and she had never made any mention of her mental health condition. And this case went all the way to the EAT, and they agreed that the company didn't have knowledge of her disability. It could not reasonably have known about her disability, and so her claim could not succeed. And the tribunal went as far as to say that they believed that the employee would have continued to suppress any information about her mental health problems, and she would have refused an occupational health report in their view. So I think that is a helpful case for employers. I appreciate it is very fact specific to the case, but often employers say to me that they feel as though the law is very much in the employee's favour, and sometimes that may feel like it's the case, but that particular case of A against Z, I think, is a helpful example.
Emma,
yeah.
Sorry, can I ask a question?
Yeah.
Where do we stand should an employee refuse to go to occupational health?
If they refuse to go?
Yeah.
Well, an employer can only find out or know about the information that it manages to obtain. So if an employee is unreasonable in that respect, if you're saying to the employee, well, we need to understand your medical condition, we need to understand what reasonable adjustments we need to make in relation to your condition, and we can't make that decision ourselves, we need medical advice to do that. And if you won't allow us to go to occupational health and get that information, then we can't be criticised for any decisions that we make, because we have to be able to rely on that medical advice. So if you can document your attempts to try and get that, then if an employee ultimately brings a claim, then you can refer to those documents and say that the employee wasn't reasonable in allowing you to approach medical advice. The alternative is that you go to a different medical opinion, for example, the GP or consultant, but in my view, they are really just repeating what the employee tells them. You don't necessarily get that sort of impartial view that you'd get from occupational health.
Thank you.
Okay, just moving on to the next slide then, reasonable adjustments. These are, again, a non-exhaustive list, but examples of adjustments that can be made in relation to stress, anxiety, depression, and mental health related conditions. We touched earlier on about the fact that sometimes employees may turn up late if they've got an anxiety related condition or they're taking medication. So a change of hours of work or change of start and finish time may be a reasonable adjustment in relation to those situations. They may need time off for appointments if they're having treatment, counselling, or some form of therapy that they need to attend. They may need more regular breaks throughout the day, and a lot of these different adjustments depend on the condition, depend on the employee themselves and the issues that they're facing. Management of workload, of course, if the employee feels overloaded or under pressure in their work, or may feel stressed because they don't have enough to do. I mean, again, that is a potential reasonable adjustment. Adjustments to role, duties and responsibilities. Very often we see cases where an employee may have received a promotion and has an extra responsibility, perhaps a managerial responsibility, which they're struggling with. And it may be a reasonable adjustment to look at, again, in conjunction with the employee and any medical advice, whether that element of the role is something that should be removed. Alternative employment, I think, is a last resort, but I think it's something that should be employee-led rather than an employer instigating. The last thing you want is the employee suggesting you're trying to oust them or remove them from their role, but it may be a possible option where an employee is struggling in their role. They may need additional time to complete their work or meet deadlines. They may need extra support from managers and colleagues. Working from home, I know most people are doing that at the moment, but that may be something that needs to be considered as an adjustment. Slide wasn't moving then. So ways to prevent it, and I'm sure this is something that already happens, but regular progress meetings and conversations with the employee so that we can understand whether there's anything behind behaviour or change in their way of working, so that issues can be addressed early. It may be that you're already carrying out return to work interviews, but that's a good way of understanding the employee's issues. If they've been off work for a long period of time, getting them back to work, what do we need to do in terms of making adjustments and understanding more about their condition, and that often leads to an occupational health referral. If employees are raising the issue of stress, then carrying out a stress audit is a good way to quickly assess the level of risk and understand what's going on and understand what needs to be done. Training managers, well, that is key, and I'm going to come back to that in a moment with another case example in the next slide. Training staff and consider whether mental health first aid qualifications is something I know a lot of businesses are investing in, to have people on site to signpost and listen and give support to employees. And of course, this ongoing need to provide support and demonstrate that duty of care. So support for employees at work and those returning from a period of absence. Well, good line management is really important here, and the need to have an open door policy. Of course, that applies when you're in the office, but certainly at the moment where people are working from home, it does make it a little bit more difficult to have that interaction. And again, that's why it's important to have managers contacting their employees. I know it's more difficult to do these things remotely, but regular calls, possible conference calls, so that people are in touch and they can understand what they need to be doing. Training managers to spot the signs. I mentioned earlier that I've got an example of this, a case we had recently, where the employee had a number of physical disabilities. New line manager came in, knew about those physical disabilities, but the employee also mentioned that he was suffering from anxiety, and he felt as though he wasn't able to deal with the public face-to-face because of his anxiety. Now, the line manager said, well, we'll find you something else to do, so you don't have to do that for the time being. He was having a period of psychiatric treatment to help get him through the 3 months of this particular anxiety he was suffering. And so the line manager really just took it that this was a temporary arrangement, but he did get occupational health advice, and that confirmed that the employee suffered from long-term anxiety, and that this latest psychiatric treatment was just one in a long list of treatment that he'd received. But for some reason, the line manager didn't treat the anxiety as a disability. He recognised the physical disabilities, but didn't consider the anxiety to be a disability, despite the occupational health advice suggesting that it was. And so he then issued a written warning to the employee for the odd days of absence, which had added up to about 8 days of absence. And when I was interviewing the line manager about this, I said, well, that day relates to a panic attack, and that day relates to him feeling stressed. Why were you not discounting those individual days of absence? And he said, well, I just saw that as being anxiety related. I didn't consider it to be a disability. I discounted all of the physical disability absence days, but not the anxiety. But he'd also spoken to HR through the HR helpline, and HR advised him that it would be incredibly risky to issue a warning to someone whose absences were disability related. But despite all of that, he still went on and gave the warning, and then promptly retracted it shortly afterwards, realising that he'd done wrong. But it didn't stop the fact that we were then on track to a disability discrimination claim. Now, we got very lucky in that case because we were ready to exchange witness statements, and the claimant was acting in person, and he wasn't ready. And in the end, after asking him a few times if he wanted to exchange statements, he then withdrew his case. But I think had we gone to tribunal on that, I think the issuing of a warning alone in relation to those disability-related absences was potential for it to be disability discrimination. Now, I know you can only train managers so much, you can only give them so much advice, and if at the end of the day they're going to go off and do their own thing and potentially cause claims, then what more can you do? But it is a sort of broader understanding by managers to recognise mental health as being disability as well as the recognisable obvious physical disabilities. So obtaining medical advice from occupational health or GPs or consultants is critical to an employer in dealing with these situations. You can't make that decision on your own, and really employees can't make that decision on their own. You need to have the medical advice, but also suggesting that employees continue to see their GP and get other forms of support, whether that's through an employee assistance program or other counselling helplines that may be available. Discuss the reasonable adjustments with the employee. What do they think they need, so that you can then go off to occupational health and say, these are the things that we're considering, and does occupational health have anything else they want to add? Constantly stay in touch with the employee, having welfare review meetings with them. It may be appropriate if they're returning from long-term sickness to have a phased return and to manage that appropriately. Of course, there will always be a zero tolerance approach to bullying and harassment to minimise any stress claims that come out of that, and then keep a watching brief on an ongoing basis, documenting everything that you do. And then the final slide relates to occupational health reports. Asking about the medical condition, asking occupational health whether they consider it amounts to a disability within the meaning of the Equality Act, many occupational health providers are very familiar with this and the definition of disability, and in most cases they tend to give a view on it. Remember, that view isn't definitive, it's a legal test at the end of the day. Occupational health may take the view that the employee is or isn't disabled, and that could differ if the test is put to the tribunal, but it's certainly a steer, and they are able to say whether or not it's a long-term condition or whether it has substantial effect on day-to-day activities, so that you know whether you should be treating it as a disability for the purposes of dealing with the employee and making reasonable adjustments.
Me again. Sorry. So with regards to reasonable adjustments, all right, this might be a stupid question, but we don't have to wait, do we, for an occupational health or medical expert to give us those recommendations if we can make if it's clear to see what they might be, like changing work hours and things like that, or is it to have that as a backup, if you like, or do you do that when all the others aren't working very well?
No, definitely. I would say that you put in your request for your occupational health referral, these are the reasonable adjustments that we are considering. These are the ones that we think would be reasonable and sensible adjustments. Do they agree that they will be sufficient, that they will assist? Is there anything else that occupational health would recommend in addition to those? But yes, you always have to remember that it comes down to what is reasonable. Occupational health may say, well, we think you should do this, this and this, but that's going to be at a cost to the business, or it's going to be an unreasonable cost to the business, and it's not one that you think is reasonable. That means that you don't necessarily have to be making it. So, but I would have thought for an organisation the size of the university, then it's going to be difficult to say, well, that's not a reasonable adjustment if it's something that is feasible and can be done.
I think I'm thinking, because we definitely take any occupational health recommendations on board, or at least advise the manager that they should be, it's before it gets to that point. So there must be some obvious things that we can do before we refer to occupational health, is what I'm thinking. So we can change work hours with a discussion with the employee, but do we need to check with occupational health to make sure that they're all right, or can we make those adjustments, monitor them, and then if we think we need anything more, then refer to occupational health?
Yeah, absolutely. There's no requirement for you to get occupational health advice on every recommendation or every adjustment that you want to be making. There's no reason why you can't speak to the employee. Employee says, these are things that will help me. You say, well, they're things that we can do now. We can get those things in place now. And then later on down the line, seek occupational health advice. Okay. Sorry, Michelle, was there anything else you wanted to ask about that, or was that?
No, sorry, that's fine. Yeah, I forgot I was on mute.
Okay, no worries. Yes, I think, we've pretty much covered off that slide in terms of the reasonable adjustments point. Yeah, asking about the treatment that they're receiving, and if the employee is off work, when are they likely to return? And in the case I mentioned earlier on, if you are looking at ultimately a capability dismissal, then if you're not able to get any foreseeable return date, then you're not going to be unreasonable at the end of the day. You don't have to wait forever if they've been off for a period of months. Okay, so that was pretty much all from me at this point in time. I can hand over to Steve. Now, is anything else? Anyone?
Sorry, just saying that you've in the chat you've got a question from Katie O'Brien that you might want to address.
Yes, sorry. So where there's a disability that displays many symptoms, it becomes difficult to distinguish or discount absences that relate to the disability. Where an absence record is high, this would result in never issuing improvements despite reasonable adjustments being made. Would the department, who are unable to sustain the ongoing persistent absences, be able to rely on what is reasonable? Yeah, no, I agree. It is difficult to discount absences. I think it can be a little bit dangerous to discount absences or try and assess whether or not it relates to the disability. But if you've got constantly high level of sickness absence and the business is struggling to manage that, then ultimately there will come a time where, and this is going to come down to objective justification on a disability discrimination claim. So if someone brings that claim, then the justification argument is, well, we just couldn't do what needed to be done because this person was never able to come in and was never there to do the work. It was putting a huge amount of pressure on everyone else in the team, and ultimately we reached the decision that we would have to give some kind of warning or sanction in relation to that person's absence. So I agree that at the end of the day, the tribunals recognise that employers have businesses to run in whatever form that may be, and if an employee is unable to do their job, unable to attend work for reasons relating to their disability, then there will come a point where something has to be done about it, and they then have to justify that. But justification arguments are not easy, but they can still be run, they can still be successful.
Thanks, Emma.
Okay. We can come back to more questions at the end, and anyone else can ask anything there or contact me separately. I'm going to hand over to Steve.
Yes, please. Okay. Thank you very much for your presentation, Emma. All employers' liability claims. Now, one thing that they're not is discrimination claims. And there's nothing different about stress claims as far as employers' liability, civil claims, from all of the other claims that could be made in relation to employers' liability for injuries that have been caused by their work. That's essentially what they are. And I was listening to Emma's presentation, and of course, discrimination claims, and correct me if I'm wrong, Emma, on this, I could make a howler here, that where someone has a disability caused by a mental impairment or stress or a mental illness, the thing about discrimination claims is that doesn't need to be caused by the actual work that they're doing. They can be suffering from a mental illness which they've had all of their life, or which has been caused by a bereavement. But the discrimination part is that where that is a disability, the employer has not taken account of that and has not put in place reasonable adjustments to help the person cope with that disability and still carry on working. Now, stress at work claims, employer's liability, is where you have a duty that the employer has towards their employees, not to take reasonable steps, not to harm them at work. I'll go into a bit more detail about the definition. And the employer has breached that duty and not taken reasonable steps. That has caused a mental illness, or in general terms, an illness. And then the claimant then produces evidence that not only has an illness been caused, but the magnification or the size or the nature of that illness, so that the court can then award damages. Those are the sort of components of an employer's liability case. And it's not a case that if your work causes an illness or causes you to suffer a psychiatric illness or a broken leg or whatever, that you suddenly have a claim against your employer. You have to show a breach of duty, and that's some of what I'm going to be touching on. I'm not going to be referring extensively to case law, but if you're interested, there's a relatively recent case. It's a 2015 case, which is a stress at work claim, and I think that it very adequately sums up the case law, and it is easy, in my view, to understand. The facts in the case are pretty straightforward. So just as a reference, I'm going to, but I'll after this webinar, I'll let you have a link to the case report so you can read it. It's only a couple of pages, and I think it's, if you wanted just a background on how courts approach employers' liability, it's very useful. It's a case of Carl Michael Easton against B&Q, and he was a manager at a B&Q in Romford and Ipswich, and he brought a stress at work claim against B&Q. I won't give you a spoiler. I won't tell you how it went at the end. But the beautiful thing about the case report is that it goes through some of the important principles of how the hurdles that a claimant has to jump over to bring a successful claim. And of course, you can look at it through the other end of the telescope, so to speak, and look at, from an employer's point of view, what things you need to be mindful of in order to reduce the number of potential stress at work claims that you may have, and how to deal with them if you have any claims or letters of claims which suggest someone's going to bring one of those. The case that really set out most of the principles to do with stress, employers' liability stress claims, is one called Hatton and Sutherland. That's a 2002 case, and really the principles that it laid down haven't been modified since then. So that's unusual in law, but it's now nearly 20 years old. It was a Court of Appeal case. One of the judges in it was Baroness Hale, who subsequently became president of the Supreme Court, and she gives the principal judgment. So it carries a lot of weight, not only because it was Court of Appeal then, but also because it's an important and well-respected judge who gave the leading judgment on it. So it's good. So that case and the one that I've mentioned, the B&Q case, and the B&Q case sets out the Hatton and Sutherland, the principles, very clearly. So it's just it's a good starting point if you fancy reading through it. Now, I said that I was going to just what I'm going to do is just go through the principles in terms of stress at work claims, and the first one is that is there a duty of care? Well, there is a duty of care, and that's the general duty of an employer to take reasonable care not to expose employees to a foreseeable risk of harm. And essentially what that means is that you as an employer need to take reasonable steps not to expose your employees to foreseeable risks of physical or psychological illness caused by the work that they're doing for you. And for a civil stress at work claim to be successful, a claimant has to prove that it was more likely than not that their work exposed them to a risk of psychiatric illness, and which the employer knew or ought to have known about. And that the employer then, once that threshold is overcome, in other words, the employer has a duty to act, the employer then failed to take reasonable steps not to expose the employee to the risk. So there's a threshold there that there has to be a reasonable, foreseeable risk of harm. and then the employer has to know about that for that particular employee. Then the employer has to fail to take reasonable steps not to expose the employee. And then as a result of that failure, that failure to act, the employee then suffered a psychiatric illness which was caused or materially contributed to by the work. So that's a bit of a mouthful, really, but that's it in a nutshell. And those are the elements that an employee has to establish. Now, what is the harm? Well, the harm is an injury to health, and it must be, in terms of stress at work claims, it has to be a psychiatric illness. There has to be a diagnosis, an accepted diagnosis of a psychiatric illness. So it's not tiredness or a bit stressed out. The person has to be suffering from an identified illness. So therefore, that component, you typically, the claimant's evidence has to include a medical report by a psychiatrist, typically, showing that employee or that claimant is suffering from a psychiatric illness, and that the cause of that psychiatric illness was the work. So there, of course, there's a difference between this kind of claim and a discrimination claim often. You have to show in these particular claims that it's the work that's caused that. You can show, and I'll come on to that later, that you can have a combination of the work, and this is often the case, and other factors. But if that is the case, and the employee or the claimant has overcome all of the other hurdles that I'll go through, the court will probably apportion damage, or at least take into account that there were other factors which led to the psychiatric illness, and the employer won't be liable for the part of the damages that are attributable to those. Now, the other element is for the, shall we say, the threshold test is this kind of harm, in other words, a psychiatric illness, for this particular employee, reasonably foreseeable? So could the employer see it coming, have seen it coming, or should the employer have seen it coming? And really there are two elements to this. There's the nature of the work and the nature of the employee. And it's usually a combination of the two, but the most important factor really is the employee themselves. In terms of the nature of the work, there's no, the case law is very clear that there's no occupation that's intrinsically dangerous. So there's no occupation where the employer, or at least there's no occupation where the employer is already on notice that a particular employee is going to be caused stress or illness by what he's doing, or he or she, what they are doing. You have to look at what the claimant has to do if the claimant is arguing that the actual occupation itself is stressful, is to drill down a bit more in the nature of the work that they are doing. So, if they are a manager, is their particular role as a manager, are they doing much more work than other managers? So what does it what sets it apart, this particular job, from other employees? So are they doing more hours? Have they got more responsibility than managers who are not going ill? Is it more demanding intellectually for the employee? Is more being demanded of this employee? And those are sort of general things where the the claimant can point to differences in the work that they're doing to all of the similar work being done by managers where the managers are not falling ill with stress-related illness. Are there, however, statistics suggesting that there is widespread illness, stress-related illness, in relation to this particular type of work? So is there a high incidence of staff absenteeism? Is there a high incidence of staff being absent from stress or due to stress? Or you can flip it around. If you're an employer, have you got good statistics saying that actually, even though our job is a stressful job, if you look at the absenteeism, it's quite low, and no one is telling us that they are absent as a result of stress. And that was something that was interesting what Emma said towards the beginning of her presentation, that a lot of, or many employees will not divulge that they're off work because of stress. And of course, that's important if you're an employer. You may not be aware that a lot of your employees may be taking time off for stress, but you certainly may not be aware that this particular claimant has taken time off stress because they never indicated to you that the absenteeism, the days that they had off, were due to their suffering stress. It's in every stress at work claim, it comes down to the claimant in most cases, and what the employer knew about the claimant, and whether the employer knew or should have been aware that the employee was suffering from a stress-related illness. And that comes down to whether the employer knew about any signs of impending ill health, whether the employer knew that the employee had a particular problem, a vulnerability. So something that sets that employee apart from other employees who get on with their work, who do go through periods of stress, but they don't develop a psychiatric illness. What can the claimant point to, which put the employer on notice that they were developing a stress-related illness, and there was a duty at that point for the employer to act? So, have they? What is probably the most important issue or factor is if the employee has already suffered an illness attributable stress. Typically, the employee has gone off with stress. That's the first time that the employer knows about it, and then comes back. And so, in other words, the employer is on notice that there is a foreseeable risk of harm, that person is vulnerable, they've already gone off with stress for the job that they're doing. If you put them back and they're not fit into the same job, then it's likely that they're going to get sick again. So that's typically the situation that arises. And so there's a rule of thumb, really, in these often in these stress-related civil claims is that the employee is not likely to succeed for a claim based on the first absence they've had from stress, because the employer is entitled to assume that an employee is robust enough to cope with the stress of most jobs. But if as soon as the employer is on notice that you have a vulnerability, that's where the employer could be on notice. Having said that, employers are entitled to take on face value what the employee says and not to make searching inquiries. So if an employee comes back and says, I'm absolutely fine, or an employer notices that the employee is looking a bit stressed at work and makes those very sensible questions, and the employee says, for a variety of reasons, I'm absolutely fine, I'm okay, then there's no need to go further from that. Certainly in these kind of civil claims, and an employer will not be criticized for not taking matters further at that stage. So, and then kind of summarizing what I've just said, really, when is the employer under a duty to take action? So when there is, and this is the wording that I've used is taken from a particular case, so it's case law, where the indication of impending harm from stress at work is plain enough for any reasonable employer to realize that they should act. So plain enough. So they're not mind readers. They're not expected to be mind readers. But if there is evidence plain enough for them to act, then they need to act. So it's insufficient for a claimant to argue that the employer knew or ought to have known that they had too much work or that they were vulnerable to stress as a result of overwork. They must show that they were at risk of a psychiatric or medical condition. So they can't just say, well, you give us all this work and it puts us under stress. Being put under stress is just, and the courts are pretty robust on this, is just part of being at work, and we go through phases where our work may not be up to standard because there's just too much of it, or we may not be smiling all the time, and we may be shutting the door and just getting on with things and keeping our head down because we're stressed. But that's not the same as us going down with a psychiatric illness. And that's the kind of robust case law that really developed after 2002. And again, it was something interesting that Emma was saying. That I would venture to say that the stress at work claims were beginning to burgeon in the late 1990s and early 2000s. And that particular case that I was saying, the Hatton and Sutherland case in 2002, put down some really quite robust principles and capped off a lot of stress at work claims being brought simply because claimants were just not able to show that the employer, it was reasonable or it was foreseeable on the part of the employer that they were going to suffer or were suffering a psychiatric illness. Now, of course, there are jobs which often cause stress. You'd think of the armed forces or the emergency services, and they're often you see employers having quite an extensive support network and referral to counselling and other forms of working through events such as mass fatalities and whatever. where people can develop stress-related illnesses. Now, that doesn't mean to say that an employee in one of those areas can bring a stress-related claim if what they're doing in combat or as a police officer causes stress to them. The employers will often refer them to counselling and whatever, but the job itself isn't regarded by the courts as something which automatically causes stress-related illness, causes stress-related illness, in which for which a claimant can automatically say, well, that was my work. My employer failed in their duty to keep me safe, and therefore my stress-related illness is their fault. Now, so assuming that the employer is aware of the employee's illness, that's the threshold. Then they have a duty to take reasonable steps. And again, Emma has gone through in her presentation quite a few of the steps that employers can take to try to ameliorate the effects of work on an employee who's clearly suffering from a psychiatric illness. There are many steps that can be taken, and there's not one size that fits all. It has to be the factors which a court will take into account to decide whether there were reasonable steps or whether the employer had taken reasonable action. Maybe the size of the risk. Is it very likely that this particular or this work is going to cause this employee harm? And then what about the gravity of the harm? So it's a risk assessment perspective in some ways. The cost, practicality of measures, and is the risk justified? In other words, it's a job that has to be done. You can't keep soldiers out of the combat zone because they might suffer combat stress. It's a job that has to be done, and you just have to. And the steps that are probably expected from an employer in that situation is what you do afterwards, and maybe counselling or treatment for post-traumatic stress disorder, or the steps you take to identify the employees who may be suffering from that. That might be the reasonable steps rather than changing the job. And then you have to look at the interests of the other employees as well. If you take all of the work away from one employee, are you putting it on other employees and going to cause them stress? So it's not just dealing with that employee in a bubble. You have to look at the whole job, the whole business as an entity. And then you can take into account the size and scope of the operation. That's a difficult one, because are you saying that if you're in a small business, it's more justifiable for employees to expose their or employers to expose their employees to stress and not to take certain measures to ameliorate that stress, as opposed to a larger operation? I think that just simply means that bigger operations can probably have their own occupational health department and have a bigger, more detailed approach to that, and that a court will take that into account. But I suspect the university won't be able to use the excuse that it's a small operation, and that when using that yardstick. And then just really, it's not a breach of duty if the employer would have had no alternative but to dismiss or demote an employee to take that employee out of the stressful environment if the employee wants to continue. And again, one of the principles that was provided by the case law is that if an employer rather offers confidential advice and referral to appropriate counselling, then that is deemed to be a reasonable step. And if they've done that, then they're not likely to be found liable for negligence and failing to take reasonable steps. And they're only obliged to take steps which do some good. So the claimant's got to show, when the claimant brings the case, well, what could they have done? And that if they'd done that, it would have done some good. So there's a number of hurdles that the claimant has to overcome. And they must establish that the breach of duty caused or contributed to the harm. That's something that I mentioned at the beginning of my presentation. And I said, again, it's insufficient to simply show that the work stress caused the harm. You have to show foreseeability and also that there's been a breach of the duty. Just turning to damages, if you look at the damages awarded for stress at work claims are essentially the court draws the information or the figures for it from some judicial college guidelines. Those are judges who put together a table, essentially, or a small booklet of guidelines about what damages should be awarded for certain types of stress, depending on the psychiatric illness, depending on the level of the illness, how long they suffered it, the effect it's had on their life, whether it's permanent, and what level of permanent symptoms they will have, and so forth. So you get some, those guidelines give you a starting point, and then case law, reported cases, give you an idea of what individual cases or claimants have been awarded. Now, you'll usually find that when you hear about stress at work claims, that successful claimants have been awarded hundreds of thousands of pounds. That's usually because they've got a rather large loss of earnings claim. They've had to stop work and they've been unable to work as an airline pilot ever again. And if you consider 2 or 3 or 4 or 10 or 15 years of earnings in a high-paid job, then that produces a very high claim. The actual general damages for stress at work, for stress-related illness, goes from about £2,000 probably up to about 50. So it's not necessarily those damages that you get a huge claim. And as I said, the contribution of other stresses will mean that sometimes claims are discounted quite considerably. The courts don't want to award damages. They won't ask an employer to pay 100% of the damages if 50% of the stress has been caused by some other factor that's not caused by the work. And similarly, if there's a previous history of mental illness, in one way that can work well for the claimant, because the claimant can say, well, my employer knew about this, I was suffering from mental illness, made me more vulnerable, therefore they should have taken these steps. That may be something in their favor. But then the flip side of that is that the employer might well say, this person had a history of mental illness, they have throughout their lives had periods of time off due to stress at work or other stresses, and therefore this particular stress or period which has been caused by our work is only a blip in comparison to all of the other time that has been caused already. And even if if they hadn't had time off due to our work, they would have been off next year or in 2 years or 5 years time, and there's no way that they would have ended up working to 65. They're probably retired at 50 anyway. So that can be a significant effect on level of damages. And then finally, just I'm looking at the passage of time, and I'm aware that Chris is champing at the bit to give his presentation. In terms of prevention, you'll see on the slide that much of what Emma said in relation to what you do in your HR departments to prevent psychiatric illness and discrimination claims is good advice in relation to preventing employers' liability cases. It's to have a good overview of the sickness patterns in your work, or the absence of patterns, as I referred to earlier, to have a confidential advice scheme, to offer counselling, and also to have a good handle on your employees, to listen to what they have to say, to record those conversations, and then make an effective plan on how their work can be adjusted when that you are aware of what they're telling you. And it's often the case that the successful stress at work claims are where employees are complaining and sub-managers are not recording those complaints. The evidence is there for employers to act, but it's not acted upon because there's a break in communication and so forth, and there's no records. Or the records of the employee saying, I'm all right, I'm okay, I'm fine to come back to work, or I've got no problems, there's no record of that made either. And so the employer is struggling then to say, well, we have these chats regularly with our employees, and they, so-and-so said they were fine. So record keeping is paramount in these cases, and monitoring of the employees. So I think that essentially brings me together to the end of my presentation. I'm going to now hand over to Chris.
Hi all, can you hear me?
Yep.
Yep.
Yeah. Yeah.
Just want to make sure, because I've switched between headset and the laptop speakers a few days in trial a couple of weeks ago, and now my ears seem to hurt when I wear these when I wear these headsets for too long. But essentially, I'm going to take you through the health and safety considerations of managing stress at work, including the Hsc's approach to stress generally, and just to give you an overview of the likelihood and potential for prosecution. So we've probably covered this off half a dozen times in this presentation already, but what is stress? And as you know, stress can take many forms, and similarly, there is a difference between civil and criminal law and how they define stress. Hsc, for instance, defines stress as the adverse reaction people have to excessive pressures or other types of demand placed on them. The Hsc understands that employees feel stress when they can't cope with pressures and other issues. Therefore, what the Hsc's position is that employers should match demands to the employee's skills and knowledge. So, for example, they provide that employees can become stressed if they feel that they don't have the right skills or time to meet deadlines. Employers should therefore try to provide the appropriate training and support to reduce the pressure and bring the stress levels down for employees. The Hsc also understands that stress affects people differently. What stresses one person may not stress another, but they do always take into account in their investigations the skills, experience, age, and any potential disabilities, which may all affect whether an employee can cope with the stress that they're under. So there are a number of reasons why the Hsc concerns itself with stress. over a number of years, and we'll touch upon this a bit later. And the Hsc has understood that well-being is a key cause of lost days, and that's something that Emma touched on earlier on in the presentation. And one of the things that the Hsc does on an annual basis is report on the number of lost days and how these come about effectively. As Emma touched on, there is evidence that prolonged periods of excessive pressure can have an adverse effect on health and therefore lost days. There are, of course, links between stress and physical issues, and research provides strong links between stress and heart disease, back pain, headaches, gastrointestinal disturbances, and various other minor illnesses, as well as the psychological effects such as anxiety and depression. Going hand in hand with that, you may find that employees adopt poor coping strategies, which can lead to other negative behaviours such as skipping meals, drinking too much caffeine or alcohol, or smoking. And we've already covered in this presentation how you might identify those coping strategies. The one important consideration is what exactly, what legislation and guidance exactly applies for Hsc and for criminal health and safety legislation. So the Hsc advises employers to use their own management standards approach. And whilst that management standards approach acts as guidance only, there are non-delegable duties which affect employers. And these come under the Management of Health and Safety at Work Regulations 1999. And the duty there is to assess the risk of stress-related ill health arising from work activities. And secondly, you have the Health and Safety at Work Act 1974, particularly in relation to employees. It will be Section 2, and the duty there is to take measures to control the risks that have been identified and assessed. Unfortunately, the Hsc identifies that it's all too often the case that legal duties do not motivate organisations appropriately. The Hsc note themselves that it is often the business case which eventually persuades organisations to do something about work-related stress. And fortunately, in some respects, the business case is a relatively strong one. The Hsc identifies that maintaining appropriate standards in relation to stress at work can help maintain business output and performance, maintain staff performance and productivity, staff turnover and intention to leave, attendance levels, recruitment and retention, customer satisfaction, where that applies, organizational image and reputation, and of course potential litigation. And it's important to note that the Hsc, and I'll cover this in more detail slightly later, are not frightened to take enforcement action in appropriate circumstances. So if I can find the button for the next slide. Just going back right to the basics, what is the starting point for employers, particularly the university? And in very short terms, the starting point is simply that employers have a legal duty to protect employees from stress at work by completing a risk assessment and then acting on it. The key point is that this is a two-stage process. Stage one is, of course, to assess the risk. And if the university is looking for any examples or templates which can be of assistance when considering their risk assessments, then the Hsc does have a number of templates readily available on their website. And one of these is actually, one of the templates they produced is based on a fictional college with multiple sites. So there should be some analogous points in there. The second key element is, of course, to act on the risks that you've already assessed. So, and we've touched on the HSC's management standards, and I think the key point is that the management standards are not compulsory. They do not need to be adopted, but where they aren't adopted, employees must ensure that they have a suitable equivalent system for managing work-related stress. And that goes to essentially following the guidance helps employers to comply with the duty. So, what and when will the HSC investigate? In simple terms, the HSC will consider investigating concerns about work-related stress where there is evidence that a number of staff are currently experiencing work-related stress or stress-related ill health, but HSC would not expect concerns about work-related stress HSC would expect concerns about work-related stress to have been raised already with the employer and for the employer to have been given sufficient time to respond accordingly. So essentially, HSC will investigate where that doesn't take place. The other thing to note is that unless there is a significantly high-profile case, it's unlikely that the HSC will seek to investigate any individual cases of stress or ill health related to stress. So, for instance, if you are met with an individual who is experiencing some stress-related symptoms, then it's unlikely, if they do, threaten to contact the HSC, for instance, the HSC will take that as an opportunity to investigate. The next bit is what falls outside of the HSC's concern. Simply put, the HSC does not seek to apply the Health and Safety at Work Act where there is more other more specific legislation, and cases of bullying and harassment would more commonly be dealt with as issues of discipline, and for example, breaches of policies on expected behaviours, discrimination, victimization, or equality would all be dealt with elsewhere. And I've put in there that where the HSC is not the primary authority on issues, it might signpost issues to Acas, for instance. In addition, more serious cases may constitute offences under criminal law, including, for instance, where there is physical violence or a breach of the Protection from Harassment Act, and correspondence will be signposted to the police in those circumstances. Now, the question of whether a prosecution is likely or not is a difficult one at the moment. And of course, as I mentioned before, this would only arise really, or was only likely to arise, where there is a widespread issue relating to stress at work and ill health related to stress. And the reason why it's difficult in any event is because there have been no prosecutions for work-related stress yet. However, there have been a number of indications that one might be around the corner, so to speak, and the HSC have themselves said for some time now that in respect of their strategy, stress is a priority area. The issue that the HSC has is that stress is still a relatively new area for them, but at the last Health and Safety Lawyers Association annual conference, which I'm told is a riveting affair. I didn't attend it personally, but I think I'm not sure that one was done remotely. It might have been one of the last ones that had a bit of a knees up after. But the main topic was of discussion was well-being, stress, and mental health. It was noted during that conference that the HSC inspectors are being provided with new training on stress management standards. That's their own guidance, and specifically how to enforce stress management standards on employers. This seems to me to be a key indicator that the HSE is gearing up for a stress-related prosecution of some kind. What we've also noticed is that while there hasn't been a prosecution for stress-related ill health in the UK, there has been a prosecution for work-related stress in France. And that was where a spate of suicides among employees at the same firm, including one man who set fire to himself outside of the office block, led to a prosecution against the employer, which was France Telecom. I did contemplate saying that in a French accent, but I'll save you from that. The big issue with the HSE bringing a prosecution will be demonstrating a causal link between the stress and the risk. I don't think there is much doubt that a prosecution will be brought at some point, but that must be based, and the HSE will consider whether their own test for bringing a prosecution is met. And the test, broadly speaking, is based on two factors. One, will there be a reasonable prospect of success? And two, is the prosecution in the public interest? Now, their own guidance suggests that if there is a death, then any prosecution is deemed to be in the public interest, regardless of the context, to a certain extent. But if you can imagine a large employer who has a good number of employees, they all, and a number of them report stress-related ill health, the HSE will likely deem that to be a matter of public interest. Now, moving on to what the HSE advises employees when they're experiencing complications with stress at work. They suggest speaking with a manager in the first instance. Where a manager is the cause of stress, the HSE advises consulting with the employer's policies, and it's important that the university has an appropriate policy in place. And the reason for that is that HSE advises that if there isn't a relevant and appropriate policy, that employees should take their concerns up either with the HR department or go straight to a third party, such as a trade union rep. Now, for the university, this is of course a key consideration, and as it is for most employers, because where issues such as this do arise, it is appropriate for or is desirable for the university to deal with it in-house, so to speak. Then moving on.
Chris, sorry to interrupt. Natalie's just asking a question there, and I think there's kind of, I mean, I want you to answer it, but I think there's kind of two answers to this.
Yeah.
Because there is also the legal requirement to do one anyway, to risk assess where there is foreseeable risk, yeah. But Natalie's in particular asking about individuals coming back from absence.
So let me just read that again. So can I just check, did you mention there is a legal obligation to do an SRA? I think the obligation is always to assess risk for employees. So if they're returning to work, it would be appropriate to do a risk assessment so you comply with your duties. and that risk assessment should be based on the contextual factors, and it should also consider appropriate steps put in place to try and prevent any further aggravation, so to speak, or prevent risk in general. I think to call an obligation is probably right. I would suggest.
So if we weren't doing an SRA every time someone came back from stress, is there cause for concern about that? Do we need to monitor them, sort of check them off that they've happened, or is it a lot less, like a bit more loose than that we can just say to a manager, we encourage you to do an SRA, and if they do or don't, that's kind of...
Yeah, I think it's a difficult question. What I'd suggest is that where you do have, where you know that an employee is coming back, having had some time away due to stress, it is important that you, upon their return from work, that the university investigates what caused their stress in the first place, what issues led to them not being able to cope, and that you work with their manager to try and reduce the further risks. Whether or not that's in the form of an SRA or not, I think if you can evidence that you've taken those steps, then that will be sufficient.
Okay, thank you.
Sorry, from our point of view, though, Natalie, probably maybe a discussion for outside of here, but it's not something that we would then sort of micromanage the manager to make sure he's done it. So, ours is you should do a risk assessment when that person returns, the same as they should have maybe prevented it if they saw it happening. So, so doing team stress risk assessments and things like that. So, yeah, so I don't think it's something we should make sure and check with the managers, if you like.
No, but it would be useful in the worst case scenario to have that as part of a policy, perhaps. Yeah. Okay, so the next slide, sorry. Should the university adopt the HSE's management standards approach? And essentially, the HSE refers to its management standards approach as an effective tool for assisting organizations to identify the causes of work-related stress and implement practical solutions to manage the risks. They are now the main standard in use in the UK. Now, it's important to note that the management standards are not compulsory, as I mentioned earlier. And the compulsory elements or the duties of the university as the employer are to essentially assess the risks and to act on that assessment. Applying the management standards is simply a way for employers to help ensure that their essential duties are met. And as I mentioned earlier, if you choose not to adopt the management standards as they are, it is important for an equivalent policy to be implemented. The management safety standards, just in a bit more detail, what they cover and what they include are essentially five or six, depending on who you believe, suggested steps to follow. The first one comes really before the implementation of the safety standards, and that is essentially to prepare an organization, and that involves securing the commitment, particularly from senior managers, but also from general staff, and to consider the need for a steering group and who might be involved in that steering group. And I'll come to a case study in a moment where you'll see that the steering group doesn't simply involve internal individuals at an organization, but also individuals from trade unions and so on. The second step is to identify the risk factors via an appropriate assessment. And in the first instance, it's advised to look at organizational level issues that potentially impact on large numbers of employees. Then third, you must evaluate the risks that you've assessed, explore the problems that have been identified, and try to develop solutions to those problems. It may be beneficial, obviously, to have, we've already discussed the steering group, but underneath that to have more specific focus groups to consider the individual risks that have been identified. And then it's always important for organisations, including the university, to record findings, to develop and implement an appropriate action plan, and to make sure this is recorded somewhere, so that in the event of an investigation, you can evidence to the HSC that appropriate steps have been taken, and that in the worst case scenario of the HSC bringing a prosecution, the university could suggest, for instance, that while it took its defence would be that it took all reasonable steps. The final step, which is as important as the rest, is to consistently monitor and review the effectiveness of action plans, and in particular, risk assessment should be reviewed if anything changes. So, for example, following a case of stress-related ill health in the workplace, or if there are any significant changes such as new work activities, appropriate risk assessments should be reviewed. The management safety standards are hyped by the HSC as being a really valuable tool. And one of the case studies that they themselves supply is that of a local council. And the importance of this case study, I think, is that the council didn't just simply adopt the management standards approach in their entirety, but they reviewed the management standards approach and decided to implement a version of them, their own version, which suited their organization. So the background is essentially that a local council introduced a revised stress management policy to provide managers with support and also advice and tools to help them effectively manage work-related stress. The initial step they took, which is the appropriate step in my view, was to establish and implement a corporate stress steering group, which was chaired by a director, and the importance of that was to demonstrate senior management commitment. The group was made up of representatives from the HR department, various trade unions, organizational development, health and well-being team, the corporate safety team, and also a number of other directorate level representatives. It's not always going to be the case that a steering group needs to be that thorough, and the university may or may not wish to include external individuals in their steering groups, but it may help to provide a second pair of eyes. Essentially, that steering group worked together to develop a series of practical solutions and assess the work-related stress and implement solutions that they consider were appropriate. Among the solutions that they adopted and among the actions they took were to circulate a corporate survey to staff, and once the results of that came back, they implemented an action plan based on the results. They introduced a stress management intranet page with advice on coping and dealing with stress at work, including details available support across the organisation. Staff were continually updated through articles in the staff magazine. Training courses were set up and staff were encouraged to attend those. And there were also changes at directorate level, including the implementation of an open door policy to encourage staff to discuss any issues. There was a work shadowing program to enable staff to increase their knowledge of the roles and responsibilities of other colleagues. There were weekly staff training sessions on teamwork and relationship building, and staff rotas and working patterns were regularly reviewed as a matter of course to ensure appropriate work-life balance issues were addressed. Now, the encouraging result for the council was that the number of stress-related sickness days were reduced by a third. And in that particular example, that equated to 13,000 days a year saved by via the implementation of these measures. In addition, they noticed that more staff were attending training and development programs rather than sticking to the day job and just getting through their allocated work, and that meant that they had they felt they had a more competent set of staff. And so I'll leave you with that on the basis that again, the university does have essentially two duties, which are non-delegable, and you can't avoid them, and they are to assess the risks posed by stress at work, and then to put appropriate measures in place for those risks. Whether or not the university wishes to adopt the management standards plan is a matter for the university, but if it doesn't do so, then it must consider an appropriate alternative, which will essentially help them comply with it, help the university comply with its duties. I hope that's been useful. And we move on to the questions and answers page.
So I'm mindful that we're already a little bit over time, and we did have questions during the presentations. But if anyone has got anything they'd like to ask us now, I'm happy to deal with those. Or if you want to email us with any questions that you have, then please do that as well. Does anyone have anything